Today is February 22nd, 2022. The time is approximately 10:04 a.m. We are now on the record. This is the beginning of Media One in the deposition of Chad Westendorf and the matter of Michael Tony Satterfield and Brian Hara versus Richard Alexander Alex Murdaugh et al. The case is in the Court of Common Pleas for the 14th Judicial Circuit, County of Hampton, State of South Carolina. Case civil action number 2021 CP 2500298. Today's location is 1500 Calhoun Street, Columbia, South Carolina 29201. My name is Chuck Habrack. I'm the videographer. The court reporter is Cindy First. We're representing Every Word Inc. If counsel will please introduce yourselves, whom you're representing, then the court reporter can swear in the witness.
It's Eric Bland, Scott Mangill, and Ronnie Richter on behalf of the plaintiff, the estate of Gloria Satterfield.
Tommy Lyden on behalf of Chad Westendorf.
Please raise your right hand and be sworn. Do you solemnly swear the testimony you are about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
Good morning, Mr. Westendorf.
Good morning.
My name is Eric Bland. I represent, as you know, the estate of Gloria Satterfield and the personal representative of her estate, her son, Tony Satterfield. We are here to take your deposition today in the case that's pending at this time against Alex Murdaugh, Eddie Smith, and I believe Bank of America. You are no longer a party. Your bank is no longer a party, and so that is the circumstances of we're taking your deposition today. It's by a videographer and court reporter. Have you ever had your deposition taken before?
No, sir.
Okay. Do you understand the rules of the road of how it's going to be in terms of I ask you questions and then you give answers to those questions, and everything's recorded by Cindy and also by the videographer?
Yes, sir.
You'll have the opportunity at the end of this deposition to make a decision whether you want to read and sign your transcript. Your lawyer will give you that advice. So with that said, let's get started.
Okay.
How many times did you meet with Tony Satterfield or Brian Harriet?
I didn't.
How many times did you ever speak to Tony or Brian?
I didn't.
How many documents did you send to Tony and Brian in connection with the work that you did as personal representative of the estate of Gloria Satterfield?
None.
Did you speak with any of the family members of Gloria Satterfield during your representation of the estate as the PR?
No, sir.
Okay. And my understanding is you were personal representative from about December 18th, 2018 until late September of 2021. Is that correct?
That is correct.
All right. Other than your initial documents that you filed with the probate court, and then the documents that Tommy helped you file in, I think, October or September of 2021, did you file any other documents with the probate court?
No, sir.
Okay. My understanding in this matter is that this was the first time you acted as personal representative of somebody's estate. Is that correct?
Yes, sir.
Okay. What did you do to educate yourself or avail yourself of what your responsibilities and duties were?
Spoke to Corey Fleming, the attorney for the estate, when I met with him.
Okay.
Asked him what I needed to do as the personal representative.
Did he give you any written documents or a list of items that you were supposed to do?
No, sir.
Did you do any independent research on your own and look up under South Carolina law what a PR is supposed to do on behalf of an estate?
No, sir.
All right. Did you talk with Alex Murdaugh at all about what your duties would be as personal representative?
I had questions when he asked me if I would serve.
Okay. Did the request come from Corey or from Alex for you to serve?
Alex.
Okay. And I know that there's a document that we'll get to where you said that you sought permission from your supervisors, whether it was Russ Lafitte or somebody else on the board. Did they give you the consent to serve as PR?
Yes, sir.
All right. Did they assist you in your duties as PR?
No, sir.
Did they tell you hey, this is what you need to do, or this is what you don't need to do?
No, sir.
Were you aware that Russ Lafitte had been a PR for the Murdaugh firm clients in other cases?
I was told he had served, but I didn't ask him.
Okay. Did you understand that as a personal representative that you were a fiduciary? Do you understand the term fiduciary?
I did not.
Okay. Do you understand it now?
Not really.
Okay. That you owed duties not only to the estate, who you were a personal representative for, right?
Yes, sir.
But did you realize that you were an officer of the court? Did you realize that?
I did not.
Okay. Did you realize that you had to be approved by the probate court to be a PR, right?
Yes.
Okay. Did you ever have any concerns about the duties, what your duties were, or what you were supposed to be doing, or you were more reactive and Corey Fleming would ask you to or tell you to do something?
Prior to accepting, I had some concerns about what liability I would have from creditors. That was my main question I asked. If there was any personal back on me.
Who'd you ask that of?
Alec.
And what did Alec tell you?
He said there wasn't any problem. It
Did
wouldn't come back
you
on
wonder whether you had to have like a bond or an insurance? Or
I did not.
Okay. And so your main concern was what liability you may have to the creditors.
Sure.
And who were the creditors? Do you remember?
I don't know.
Do you remember whether they were medical providers, funeral homes, or anything like that?
No, sir.
All right. Do you think it was your job to find out who the creditors of the estate were if you were going to be the PR?
Again, I asked the attorney what I needed to do.
Okay. What was your job as PR? Tell me what you were supposed to do.
I don't know.
Were you supposed to be just in name only, or did you have actual affirmative duties? You don't know?
I don't know. I mean, my first meeting with Corey, I asked what I needed to do as personal representative. Did I need to?
And what did he tell you?
Guidance. He said nothing at this moment. I'll take care of it. And I asked specifically about opening an account. Did I need to open an account? Did it need to have an estate account? And he said, not at this time.
Well, did you have a fee agreement with the estate that would set forth how you would be compensated or what your scope of duties would be?
No, sir.
Did you ever think that you needed such a fee agreement?
I didn't know of that. No, sir.
Did you ever educate yourself on what the actual claims were that were being made by Corey Fleming on behalf of the estate or the PR against Alex Murdaugh? Did you ever educate yourself on those claims?
On the accident?
Yes.
I was told in the judge's chamber the first time we met what those were.
So when you accepted to become PR and before you actually got approved, there was a gap in time.
Yes, sir.
You didn't educate yourself on what the claims were?
When I accepted initially, I wasn't aware of what the case was. And after I accepted, then I was told what the case was. But from that point forward, no.
So the first time you really found out about it was when you went to Judge Mullins' chambers on December 19th, the day?
Correct.
Is that you're accustomed to accept a title or an office without understanding what the office would entail?
Object to the form. You can answer if you can.
You know, somebody names you as president of the banking association. Do you say, well, look, I need to know what my duties would be or what I'm supposed to do as a president and what it's all about? You understand?
Yes, I understand your
I'm
question.
a little
Yes.
taken back
Yeah.
that you would accept becoming a PR for a claim and not really understand what the claim would be. Did you find it strange that Alec was the one that was asking you to be the PR when he was the, quote, target defendant? There hadn't been litigation started, so there was a claim. You understand the difference between a claim and litigation?
No.
Okay. At that time, Corey had written Alex is homeowner's insurance carrier and the excess carrier and made a demand for the death of Gloria Satterfield. Do you remember hearing about that?
Yes.
Okay. And that was not in litigation. Corey didn't file a complaint. Alex didn't get a lawyer that answered the complaint. There weren't depositions. He wrote a letter, and as a result of that, the primary carrier tendered their limits, and then the excess carrier offered a portion of their limits. Are you aware of
Yeah.
that? Okay. So when you accepted to become PR, did Corey give you all the documents?
No, he did not.
To say, hey, here's what I've demanded. You know, the accident happened on February 2nd. The dogs caused Gloria to fall down the stairs. We're making a demand of these carriers. Did Corey do that?
No, sir.
Okay. Would you agree with me, just because somebody falls on a property and dies, that doesn't make a landowner liable, right?
Object to the form.
Did you
Excuse me.
You can answer if you can.
did you educate yourself?
No, I did not on insurance, no.
Okay, did you educate yourself on finding out what was Alex's responsibility for Gloria's death? Why does his homeowner's carrier and his excess carrier have to pay? Did you ever
I
ask
didn't
those questions?
investigate, no, sir.
Okay. So from March 28th, 2018, up until December 18th, 2018, when you became PR, Tony Satterfield was PR. And you told me you didn't meet him, you didn't speak to him or whatever. What made you more qualified to be PR than Tony?
I don't know.
Did you ever ask why Tony shouldn't continue to serve?
No, sir.
Did you know that Tony was the PR and that you were replacing him?
I saw in my document from the probate that I was successor PR.
Okay. You appear to me to be a very serious individual. I've done some research on you. You know, you're well regarded in the Hampton community. I mean, you would agree that to take on this responsibility to be personal representative of an estate is a serious thing.
Yes, sir.
Okay, and I assume that you wanted to take it seriously.
Yes, sir.
Now, looking back in hindsight, I would think that you would say to yourself, I wish I would have done this or this or this, right?
Yes.
Okay. So, in this case, Tommy sent me your complete file.
Okay.
And so I'm going to show you as Exhibit 1 the documents that Tommy sent to me. And these are bait stamp number Westendorf 000001, 5 zeros and a 1 through 65. And I'm going to ask, just to review it, I'm not going to ask you questions, but do these appear to be the extent of the file documents that you had in connection with your duties as PR?
Yes, sir.
Okay. And those are documents that you either obtained or were sent to you? I assume Corey would have provided those to you, Corey Fleming.
Some of those.
Some of those, okay. Would you agree with me that up until the time you actually resigned as PR in late September 2021, you continued to owe duties up until that time to the estate, which you were personal representative, as well as to the probate court?
Could you ask that one more time? I'm sorry.
Would you agree with me that up until the time that you resigned in late September 2021, that you would have continued to owe duties up until that date to not only the estate, but as to the probate court?
I understand that now, yes, sir.
Okay. So that is the extent of the documents that you have in your possession.
Yes, sir.
All right. So I'm going to show you exhibit number 1, and we're just going to run through these real quick. Yeah. I mean, exhibit number 2, sorry. Here are the, this is 2. This is the initial documents that were filed by Tony Satterfield. Did you ever get a copy of these? This is when he became PR and he filed the initial inventory of Gloria Satterfield. Brian renounced, he would renounce his right to be a PR. And this is Tony's initial documents dated March 28th. Did you ever see these before you became a PR?
No, sir.
Did you educate yourself on what the inventory of the estate is? Do you know that expression that I'm saying?
Now I do. But
Okay.
no, I did not, to answer your question.
That neither Alec nor, do you prefer that I call him Alec? I call him Alex.
Whatever.
It confuses me. That neither Alex nor Corey said, hey, you need to understand.
No, they did not.
Do you know how much was the initial inventory in the estate?
Now I do.
About $26,000?
Yes, sir.
Okay, and when you filed your inventory, you said it was $26,000 too, is that correct?
Yes, sir, I did.
Object to the form. But
Your exit inventory, is that
Accounting.
correct? Is that correct?
just for the record, it was his accounting.
Accounting, sorry.
That's all right.
Thanks, he's better at it than me. When you filed your accounting, you filed it as the same amount as the initial inventory, is that correct?
That is correct.
And you never advised the court, the probate court, about any of the settlements, the $505,001 and the $3.8 million. You never advised the probate court about those, did you?
No, sir.
And you were aware that $50,000 of the overall settlement amount of $4.3 million, $4,305,000, $50,000 was allocated to the survival claim. You aware of that?
Yes, sir.
Okay. Do you know the difference between wrongful death and survival?
No, sir.
Okay. Did anybody tell you that the survival claim, the survival money, the $50,000, had to be paid to the probate court?
No, sir.
Did you have an understanding that if it was your job to get money or assets to advise the probate court, if the probate court had to be the recipient of those assets? Did you realize that?
I would have thought so, yes.
Okay. Tell me why you never even marshaled the $50,000 and paid that into the probate court.
I asked Corey what I needed to do, and he said he would handle it. I know I'm saying that. And he was going to pay some medical bills. This was at our first meeting. This is the
But
first
I'm
time.
talking about after the settlements came in, you know, after the first settlement conference on December 19th.
He said he was going to handle it.
Okay. So is it fair to say that your answer or defense for what you did or didn't do was based on the reliance of your counsel?
Yes, sir.
So it was Corey Fleming who told you what to do and not to do, or you expected that Corey Fleming would tell you what to do or not to do?
I was expecting that, yes, sir.
Okay. So who prepared the probate documents for you to accept to become PR? Did Alex's firm do that?
I would assume so.
Not Corey?
No, sir.
Okay. Did you deal with any of Alex's paralegals
No, sir.
How did you get the document to sign your name and do that? Did Alec give it to you?
He brought it to me.
Okay. All right. The next document I'm going to show you is exhibit number 3. This is a letter dated 5/24/2018, so it's a couple months into when Tony's PR, before you became a PR that year. This is the Murdaugh firm actually writing a letter to Trident and Anesthesia Group saying that they represent Michael Satterfield as the PR for the estate of Gloria Satterfield. You see that?
Where is that?
First line.
Oh, okay. Okay.
Did you ever see this letter before?
No, sir.
Did Corey Fleming ever tell you that not only he, but the Murdaugh law firm and Alex Murdaugh were also representing the estate of Gloria Satterfield?
No, sir.
Were you ever made aware by Alex that he had sent out letters saying that his law firm had represented Gloria Satterfield in the estate?
No, sir.
Okay. Now, you were having discussions before you became PR and after you became PR with Alex Murdaugh about these claims, right?
Object to the form.
Did you have discussions with Alex, obviously, before?
Not about the claims, no.
Okay. But you had discussions with Alec about becoming PR?
Correct.
Okay. Did that strike you as curious that the target defendant was having discussions with you instead of the plaintiff?
Not really.
All right. Why didn't you find that strange? Did you think that everybody had a unity of interest?
No, but I thought he was helping the kids out. That's what he claimed to be doing. He was helping the boys,
Doing what? How to help them?
getting them money
To do what?
because they lost their mother.
Okay. And was it also to pay medical bills too?
He didn't say that.
Okay. Have you ever been involved in a lawsuit before?
No, sir.
Anybody you know that has been in a lawsuit that you know of?
No, sir.
The concept of a defendant, you know the difference between a plaintiff. The
Yes, sir.
concept of a defendant helping out the plaintiffs is not a usual concept that we see as lawyers. You would agree?
I would agree.
Okay.
Yes, sir.
So in this particular case, there seemed to be cooperation between Corey and Alex and what was being done to facilitate the claim in connection with Gloria's death. Is that a fair statement?
Yes.
Okay. So you never saw this letter?
No, sir.
Okay. The next document is exhibit number 4. And this would indicate that Alex's paralegals are, do you know who A. Griswold is
No, sir.
at Alex's firm?
No, sir.
Do you know who Tanya King is?
No, sir.
Do you know whether Tanya King is the paralegal to Corey Fleming if you look under the...
Yes, reading that, yes.
Okay. So would you see here that they're communicating with each other to get signatures of Tony Satterfield as the PR?
Yes, sir.
Okay. But you had not seen that document?
No, sir.
Okay. All right. Give me a second here. All right, the next document is exhibit number 5. Did you know that Tony, prior to you becoming PR, was seeking advice from Alex about bills that came in about the insurance policy from Vanderbilt and then Trident Hospital? Do you know Trident's relationship to this whole matter?
Now I do. Yeah.
You didn't know then?
I did not.
Did you ever find out who Gloria was when you became her PR? Did you know that she was the housekeeper?
Yes.
Did you know that she had died?
Yes.
Did you know she had died at the Mazzell property?
Yes.
Who told you all that?
Alec.
Alec did. Okay. Did he tell you? What did he tell you about her death?
That she had a fall with his dog.
His dog or dogs?
Dog.
Okay. And that she
Hit her head
and then
and spent some time in the hospital, and then she passed away from the injuries.
okay. So you were unaware when you accepted a PR that Tony was seeking legal advice all throughout 2018 from not only Corey Fleming, but Alec as well?
I had no idea.
Okay. Next is Exhibit 6. Do you remember the date that you were approached by Alec to become PR?
I want to say it was November the 21st. I know it was the Wednesday before Thanksgiving.
Okay.
Because I was in the mountains with my family, and he called me.
He called you on the phone?
Yes, sir.
And he had your number?
Yes, sir.
Well, did he have your number because you guys were friends or because you were a banker?
I would say it would be more friends because I didn't bank him.
Okay. So how did you know him?
Grew up around him and just been in the town.
Would you call him a friend?
Yeah,
Did you socialize with him?
no.
Okay.
I mean,
And does your wife have any relationship to him at all?
no.
Okay. So this is a letter that Corey Fleming wrote demanding the $500,000, and he put a deadline that they had until 5 p.m. on November 12th to respond. Were you aware that there was a demand when you were asked to become a PR that insurance proceeds be paid of $505,000?
No, sir.
Okay. Do you know who Scott Wallinger is?
No, sir.
He was the attorney for Lloyd's. Do you know who Lloyd's was?
Insurance company.
Were they the primary or the excess? Do you remember?
They were the first one.
Right, which is rare. Usually when you think of Lloyd's, you think that they're the excess. But this one, and who was the excess in this case? Do you remember?
I believe Nautilus.
Nautilus, okay. And Nautilus was represented by a guy named John Grantland. Did you ever meet him
Over the phone.
over the phone?
Yes, sir.
What was that for during?
Mediation.
So it was like COVID times or whatever?
No, sir. I just was unable to make it due to bank stuff. I was
Okay.
several out of the bank.
I was told that neither Wallinger nor Grantland came to either hearing in front of Judge Mullen. Is that true?
That's true.
Okay.
That I was at.
Right.
Let me say that.
So the two settlement hearings that you attended on December 19th, 2018, and then May 13th, 2019, it was just you, Corey, and Alex, and then Judge Mullen.
And her clerk was
Her clerk.
at the first one, and then the second was just Judge Mullen, myself, and Corey Fleming,
So the only difference was there was a clerk at the first one.
and Alec. Alec wasn't at the second one.
Alec was not at
No,
the...
sir.
So at the second one, who was there?
Corey Fleming, me, and Judge Mullen.
Okay. All right. I'm going to show you exhibit number 7. This is the creditor's claim that was filed by a law firm for one of the medical providers, and this was the hospital, and it was for $655,539.60. Do you ever recall seeing a copy of this creditor's claim in the probate court file?
Not early on, after the fact.
Okay. When you became PR, did you go to the probate court and say, hey, I want to see a copy of all the files?
No, sir.
Do you know whether that's your duty to actually
I did
review?
not.
Review. Do you know today whether you would have a duty to review the probate?
Yes,
file?
sir.
Okay. And you did not do that, is that correct?
I did not go to probate court, no,
Okay.
sir.
Do you realize that as a PR for the estate, if there's creditors that have filed claims against the estate, you have an obligation to deal with those creditors on behalf of the estate?
Yes, sir.
Okay, and so a creditor filed a claim for $655,000, and then throughout the course of your becoming a PR, you learned that $50,000 would go to the survival of Gloria for her death, right? and then the rest went for wrongful death. Do you know the difference?
I do now, yes,
Okay.
sir.
You didn't know the difference?
did not.
Did Corey ever explain that to you, what the difference was?
No, sir.
That the wrongful death travels outside of the estate, and survival has to be an estate asset, the survival monies. Do you know that now?
Yes, sir.
Okay. Do you know how it was determined that $50,000 would only be allocated for survival?
I don't. Gloria
Gloria lived 3 weeks, right?
Okay?
She died February 26th after the fall. So, and $4.3 million was recovered, which, did you ever educate yourself on whether that was a good settlement or not a good settlement?
No, sir.
Do you realize that you actually had to approve that settlement?
Yes, sir.
So when somebody came to you and said, look, we've settled for $505,000, did you say, why are we settling for that amount, or what's the status? Is there any more insurance money? Did you ask those kind of questions?
It was told in the meeting with Judge Mullen on the 19th that there was another claim out, and we might have some mediation on that. So
Okay.
the first one was for 500 that we were in.
All right,
then-
and so when you go to the mediation and it settles for $3.8 million at the mediation.
Yes, sir.
What did you do to satisfy yourself that that was a good settlement, or whether you should have gotten more on behalf of the estate?
I thought it was a good settlement, but no, I did not educate myself. Corey called me a couple days after mediation and said that they're willing to settle for the 3.8. Our use of, is that good with you? And,
You realize you're the client.
sir,
You realize you were the client.
I did not.
Did you? You never realized that you were Corey's client.
I thought we were working together.
Okay, but that Corey owed duties to you as an attorney. Did Corey ever sign a fee agreement with you
No, sir.
explaining what he would do for you?
No, sir.
Okay. But you realize that it's your duty, once you accept to become PR, is to prosecute a claim on behalf of the estate. And that was a claim against Alex. That's your duty. You realize that? You got to say yes,
Yes.
or no. Okay. And whether Alec was your friend, you accepted to become PR where he was the, quote, target defendant, right?
Yes, sir.
And it would require you, am I correct, to put aside your friendship and do what was in the best interest of the estate which you represented. That would be your single-minded focus, right?
Yes, sir.
Couldn't do what was best for Corey, right?
Yes,
Couldn't do what's best for Chad.
correct.
Couldn't do what's best for Alec. Had to be for the estate and the estate only.
Yes, sir.
Okay. So you got paid $10,000 on the first settlement
Yes.
as the PR fee, and then you got paid $20,000 on the second settlement. How was that determined?
I have no idea.
Did you negotiate that with Corey and Alec?
No, sir.
Did they call you on the phone and say, what would you want?
No, sir.
Did you understand what it was for?
Yes, sir.
What was it for?
I was told it was from a PR fee.
Okay. Well, what did you do for that fee?
Went to meetings with the judge and
Two
was on-
hearings.
and then was on the mediation call.
That would be it.
That would be it.
Okay. Do you realize as the PR, you had a duty to account for monies?
I do now.
Okay. Do you realize that, like, when Corey would take legal fees and costs in connection with these settlements, it was your job to verify that?
I did not.
Object to the form.
Did you ever verify reimbursements or costs that he was claiming for this claim?
No, sir.
Did you ever verify his entitlement to a legal fee?
No, sir.
Were you ever made aware that contingency fee agreements in South Carolina have to be signed by the lawyer and the client?
I didn't know that.
Do you know what a contingency fee
No,
agreement is?
sir.
Okay. Tommy works by the hour. I'm a contingent lawyer, so you pay him or somebody's paying him by the hour to work. He gets an hourly rate. Me, I work based on if I recover something, I get a percentage.
Okay.
And that percentage can be 33 1/3% is kind of the market rate. Sometimes it's 40%. But our rules of professional conduct say that if I'm going to collect a contingency fee, a piece of the outcome, I'm willing to give my time. But at the end, if there's a recovery by settlement or verdict, and I'm getting a percentage of that, there has to be a signed writing. So you recognize that you were the client, right, of Corey?
Now I do.
What gave him the right to collect the legal fee if you didn't ever see a fee agreement with him?
Object to the form, but you can answer.
I don't know.
Okay. Would you agree with me that you were responsible for making sure that the estate got the money that the court ordered?
Yes.
Okay. And so if the court ordered my clients to get $2.765 million and they didn't get any of that, whose responsibility was that?
I had no opportunity to give him that money. I never received the funds.
But the checks were made payable to you that I'm going to show you.
And to Moss and Kuhn,
Okay.
and it went into their account. I didn't have any opportunity to get any. I mean, it had to come out of their trust. This is how I was viewing it.
Okay. But do you realize you actually had the right to get those checks as a PR?
No, I did not.
Okay. You realized you signed documents regarding the disbursement of those checks.
Yes, sir.
So when you signed a document, wasn't it incumbent upon you to make sure the checks were dispersed properly?
Yes.
Okay. And if somebody's charging $11,500 of expenses on the first $505,000 settlement, wasn't it incumbent upon you to ask what were those expenses for?
Object to the form, but you can answer.
I guess. I don't know.
I'm not trying to trick you. I'm just.
No, I mean, I don't. I don't know what those were. I didn't ask. I trusted Corey was doing
Well, when you
what was
see
right.
something that says 11,500,
Yes.
and then I'm going to show you the second disbursement sheet says 105,000 even. Didn't your antenna go up and say, how does expenses come out on the perfect zero? Not, 500, not 105,037 cents.
I wasn't aware. I mean, it's not something I ever looked at before, and I had no previous experience with it.
But you got common sense.
Yes.
Okay. And common sense would tell you this claim was not in litigation, right?
Yes.
You never were asked to attend depositions.
No, sir.
Okay. And the only thing that took place were a couple demand letters and then a mediation. Obviously, you had to pay the mediator. That was John Austin in Charleston, right?
Yes, sir.
Okay. So if you have a mediator cost and you have a couple stamps and maybe a filing fee for the probate court for you to become PR, did you ever ask yourself, what could comprise $10,500 and then another $105,000 of expenses? How
No.
is it that a lawyer or a law firm put that down in front of a judge and said to the court, we have $105,000 of expenses in a settlement where there was no litigation? No deposition transcripts. Cindy does this today. This will cost $800,000. None of that. No expert witnesses. Nothing. Today, can you tell me what that expenses?
I cannot.
You permitted that money to be taken from your client, the estate. You signed a document, and we'll show you, where you admitted that those were proper expenses, and that money came from my client's recovery for their mother's death. And nobody ever explained that to you, what those expenses were?
No, sir.
And it never, like, dawned on you to say, how's that possible, that amount of money for expenses?
No, sir.
Do you remember at the settlement conferences with Judge Mullen, somebody would have to make a representation as to what the disbursements would be? Who did that?
Corey.
And the December 19th hearing, and we'll go in detail, he would have said, I have $10,500 of expenses.
I don't remember.
Do you remember May 13th, he would have said, Judge Mullen, I have $105,000 of expenses.
I don't remember if he said that exactly, no.
Do you remember Judge Mullen saying, how's that possible? How are these numbers possible?
No, sir.
Do you remember Judge Mullen saying, where's your fee agreement, Mr. Fleming? How are you entitled to 33 1/3%?
No, sir.
Did she ever say to you, Mr. Fleming, how are you entitled to $30,000 as a PR fee when the statute says your money comes from a percentage of the survival settlement?
Never was mentioned.
So the survival settlement was $50,000. 5% of that is $2,500. Did you ever ask Corey Fleming, how is it that I'm getting $30,000 when the statute says I'm only supposed to get $2,500?
No, sir.
Did Judge Mullen ever ask, how is it that you're getting $30,000? Do you have a fee agreement, Mr. Westendorf? Did she ever ask that?
No, sir.
Okay. All right, I am not going to use exhibit number 7, or number 8. Actually, I'll read number, so to strike that. Number 8. This is a letter from Corey Fleming to his paralegal on November 28th, and it says, I need the I-9 for this, and the check is to Chad Westendorf as personal representative of the estate of Gloria Satterfield. So on November 28th, an I-9 is being given. It's actually a W-9. It's supposed to be not an I-9, but they're cutting a check for you as personal representative, and you were not even the PR yet.
No.
Did you have any idea this was going
No,
on
sir.
at the time?
First time I've ever seen that.
And so you said before Thanksgiving, which would have been November 26th, Alec had asked you, and you said yes.
It was actually around the 21st.
21st, sorry, but before Thanksgiving.
Yes. He had contacted me that Wednesday, but that's the first I've seen of this.
And then you went to Russ, and Russ said, sure, you can do it, right?
Russell and Mr. Lafitte both, yes.
And then you went back and told Alec, we can do it.
Yes.
I can do it.
Yes.
Okay. All right, the next one is exhibit number 9. And this is from Tanya King to, I guess, the lawyer at the law firm that was paying the $505,000. It says, attached is our firm's W-9, and the payee instructions are as follows: Chad Westendorf as PR and Moss, Kuhn, and Fleming. You see that? But on November 30th, did you know this had been sent?
No, sir.
Okay.
And I don't believe I agreed by then. I don't think I had agreed to be in the PR by then.
By November 30th?
I don't think so.
Okay. Next is exhibit number 10. This is December 6th, and this is a letter to Corey from Scott Wallinger saying, enclosed is a check made payable for $505,000 made payable to Chad Westendorf as PR of Gloria Satterfield and Moss, Kuhn, and Fleming. You see that?
Yes, sir.
Were you aware that on December 6th the actual settlement check had been paid?
No, sir.
When did you become aware that there was a settlement check?
The 19th,
At the 19th.
December 19th.
Okay. So on December 19th, when you became aware, did you think that I need to call my clients and tell them, hey guys, there was a settlement for $505,000?
I thought Corey was in touch with them.
But
I mean-
who are your clients?
My clients were the boys now, that I understand that.
Okay. Well, when you say I thought that Gloria was in touch with them, what made you think that Corey was in touch with them?
So I was told at that first meeting that Corey was the attorney for the estate, and I thought
But nobody told you, like Corey didn't tell you, hey, I'm going to keep the boys abreast.
No, sir.
And you certainly didn't see a letter from Corey to the boys saying, hey, by the way, I just settled, Chad and I settled the initial claim for $505,000. You never saw
I
that.
never saw that, no.
You realize that the boys are real live people,
Sure.
okay? And that they have a right to know if money's recovered in connection with their mother's death, what that amount was, right?
Certainly.
And that duty would come to you. You understand that?
I understand that.
Because your lawyer's going to tell you that Corey Fleming's going to say, my client was Chad. My client wasn't the estate. Now, we disagree with that. We think the law has a foreseeability angle to it that, you got to look past the PR downstream to the estate. But Corey's going to say, I represented Chad. And it's Chad's obligation as the PR to keep his estate informed. So you were unaware that the boys were unaware.
Yes, sir.
Okay. Funny thing to say, isn't it? All right, let's do the next exhibit is what, Scott? Exhibit number 11. This is the actual check for the first settlement. And it's dated 12/4/2018, and it's made payable to Chad Westendorf, PR of the estate of Gloria Satterfield and Moss, Kuhn, and Fleming. And you executed this as Chad Westendorf as PR of the estate of Gloria Satterfield. Do you remember when you would have executed this check?
The 19th.
The 19th, okay.
That's what I remember.
And you did this in chambers, did you execute it
Yes.
there? Or did you execute it before being in chambers?
We were in a room in the courthouse. I don't remember if Judge Mullen was in yet when I signed
Okay.
this document, but yeah, that's where it was because that's the only time I met with Corey.
Have you ever been in court before where there was a stenographer like Cindy,
No, sir.
taken down? But there was no stenographer when you were there on the 19th, is that correct?
No, sir.
Okay.
Oh, you asked it in the negative and he answered it in the negative, just for the record.
There was a court reporter?
There was no court reporter present.
Right, there was no court reporter present. And that didn't strike you as unusual?
I had no clue.
Right, based on
I've never been in
lack
that
of
situation.
experience.
Yes, sir.
Okay. And that settlement conference was attended by Alec, by Corey,
Myself,
and her,
Judge Mullen, and a
and a law clerk.
I guess it was a clerk. She was a young lady with Miss.
Okay, and
Judge Mullen.
that conference happened before Mallory Beach's untimely death in February of 2019. Are you aware of that timeline?
Yes, sir.
Okay. So, who presented the settlement to Judge Mullen?
Corey.
Did Alex speak?
Yes.
What did Alex say?
He gave background about the fall
Okay.
and the situation. And that's when he talked about the boys. They're wanting to help. and
Okay.
Take care of them.
And do you remember asking yourself or wondering why Alec didn't have his attorneys there with him? Did you
No.
know at the time that he had two attorneys, Scott Wallinger and John Grantland?
No, sir.
Okay. So it wouldn't have struck you funny that defense lawyers who, represent Alex and these insurance companies are paying checks aren't at a settlement conference?
I wouldn't have known.
Okay. All right. How long did it last?
I would say if I had to guess, we were there 30 minutes, 45 minutes tops, maybe,
Okay.
if I remember right.
All right, and so I'm going to show you exhibit number 12 right now. All right. So tell me everything that happened there. I mean, did Judge Mullins say, I think this is a good settlement? You know, did Corey say, this is just the first part of it, we're going to make claims against an excess carrier? Tell me what was said.
I believe there was a statement in there that there was be an excess carrier, to go by your words, and that we were going to file that, and that this was the first suit, and that he was going to pay some medical out of there, and
Who was
the
going
rest
to pay
would go-
some medical?
Corey was going to pay some of the medical.
Do you remember
expenses.
him saying what the medical bills were? at
No,
the
sir,
time?
I do not.
Okay. Did Alex say, hey, it was my responsibility for her death?
I can't recall.
Did he say, look, it was my dogs, they got out of hand,
That's
they were
what they-
unruly, it caused her to fall, and I feel like I'm responsible?
He went into that, she was on the stairs, the dogs were jumping up and caused her to fall.
Did Judge Mullen ask you, do you think this is a fair settlement?
She did not.
Did she ask you, are you satisfied with the services of your attorney?
I don't believe so. I don't remember
Meaning
much
Corey Fleming?
Yeah, I don't believe,
Did
I
she
don't
ask-
much conversation between Judge Mullen and myself.
She didn't ask you, do you think this is in the best interest of the estate to agree to this settlement?
I don't recall that.
Okay. Did she say to you, or somebody, look, I need an order, we'll get this order signed and get it filed? Do you remember any of that kind of conversation? Do you remember anything, I'm told that it took almost 30 to 45 minutes, the settlement conference. Do you remember any other conversations about the settlement? Do you remember?
There was some personal talk, like right when she came in. I mean, you could tell that they were acquaintances and asked how everybody was doing, but other than that.
At that settlement conference, were there any discussions about a structured settlement?
I had heard Forge for the first time that day.
On December 19th,
Yes.
you heard the
'Cause
word forge?
Yeah, they said they were sending the money for the boys to Forge.
Who said that?
Corey.
And did you ask what is forge?
I did.
And what did they say?
It was an annuity investor or a construction settlement, what I found out later. But basically what I understood that day was it was an annuity financial company.
Right.
I had never heard of it before that. I didn't know what that was.
Okay, and one of the things I'm curious about is, did Judge Mullen approve that there was going to be a structure to forge?
Not that I'm aware of.
But there was discussion in
Yeah.
front of her that there was going to be a structure.
I guess. I mean, yeah. I mean, I was sitting there in her chambers and we discussed. That was the first time I heard Forge.
Okay. What was the structure supposed to be?
I have no idea.
What was the structure supposed to be for Tony?
I don't know.
What was the structure supposed to be for Brian?
I don't know.
Well, you saw checks going to Forge.
I did not.
At various times, did you not?
I did not see those.
You never saw any
I
checks
never saw a
going to
check
Forge?
going to Forge.
But if a structure was being, we're told that you were brought on because Alec told Tony that there were going to be business issues with some settlements coming in, and it would be better for somebody like you, Mr. Westendorf, who has a business background, to handle that. Is that something that you remember hearing?
No, sir.
Did you ever ask why I'm coming on board and why Tony's gone out?
I did not.
Okay. So when you heard Forge, did you not say to yourself, hey, what structure is going to be? There's two boys here. Oh, is there a structure for one and not the other, or both? Did you ever ask that?
I did not.
Did anybody ever tell you on December 18th that one of your heirs that was an heir of the estate was a vulnerable adult.
On the 19th, they did.
Who told you?
Alec was mentioned that.
To whom, Judge Mullen?
The conversation in there that day
What did he say?
said that, like you said, he was, I don't know, I can't remember exact words, so I don't want to say it, but he made it aware that he had special needs.
Special needs.
No,
Was there ever a talk that he should have a conservator?
no, sir.
Do you know whether Tony's needs are different than Brian's needs? Brian's, by the way, is the special needs kid.
Yes, sir.
Did you ever, inquire as to what are Tony's needs as opposed to Brian's needs?
I did not.
Did you ever ask why is there a structure?
No, sir.
What's the reason for a structure when people are over 18 years old in their 30s?
I have no idea. I can't answer that.
Were you aware that structures are usually for people who are like minors or people who are incapacitated and they'll need medical needs throughout their life, so you want the money to last? Did you have any reason to ask why we're doing a structure as opposed to dispersing the money?
I didn't.
Okay. All right, I'm going to show you exhibit number 12. 13? Okay, 13.
I think it's 12.
Last one I have is 11.
Okay, so it is 12. I don't know.
You put something down on the floor.
No, this is this.
Okay.
Here it is, 12. So this is you on the 18th, or, excuse me, this is Chad. The dates are actually wrong at the front if you look at it.
Yeah.
It's not March 28th. They used the same date for Tony when he became the PR. But the correct date's at the bottom where Sheila Odom signed. So you became the PR on December 18th. Is that correct?
That is correct.
And that's when you assumed your duties.
Yes, sir.
And you put on here that you were vice president of the bank and you gave your banking address as opposed to your home address, if you look in the back.
Where is that?
On page 3 of 3 on the back, you gave your banking address as being the address you wanted mail from the court. So did the probate court ever send you mail?
No, sir.
So you never got any mail there at all?
No. And I didn't type that, just to
Okay.
let you know.
And if you look, Christy Gerald was a notary for some of that. Did you ever find out who Christy Gerald was?
I assume she's a paralegal for Alec or works
Okay.
for Alec's secretary.
That's fine. All right, and so that next day after you become PR, the next exhibit is 13. A petition is filed to approve a wrongful death settlement and you sign the petition as PR for the estate of Gloria Satterfield.
Yes, sir.
Who's Margaret Grill, notary?
She works at the courthouse,
She works at the courthouse, okay.
or used to. I don't know if she's still
And you were seeking approval on behalf of whom?
Tony and Brian.
For $505,000, right?
Correct.
And the caption was now you suing on behalf of the estate as PR versus Alex Murdaugh.
Correct.
And that's the first time we've ever seen a caption in this case. You understand when I use the word caption, meaning a court caption.
No, I didn't know that.
And so going forward, the caption in the courthouse, because this was filed on December 19th, you
Yes,
see
sir.
right there.
Yeah.
That's the caption. And the court term is now 2012 CP 25-00298. You see that?
Yes, sir.
So that's the Court of Common Pleas caption, and that's the case number that it's going to have. And you were seeking approval of a settlement, right?
Yes, sir.
Okay. And you told me that after Corey spoke and Alex spoke, did you actually speak at all?
No, sir.
Never spoke?
No, sir.
You weren't asked any questions or anything. It was approved.
Yes.
Do you remember whether an order was signed at that hearing?
I don't.
Okay. Did Mr. Lafitte ever, Russ Lafitte, ever tell you about his experiences of being a PR and what it entailed and what it should have done?
No,
did
sir.
Did he give you any advice or rules of the road?
No, sir.
Did he encourage you to do it or tell you not to do it? Did he say, hey, this is a good thing, you can make some side money?
No, sir.
Did the bank let you keep the money to be PR?
Yes, sir.
Okay. So you didn't view this as anything but a one-off? This wasn't something that you were thinking like, I'm going to start now being a cottage industry, being a PR?
No, sir.
Okay. So my next exhibit for you is 14. And this is a check from Moss, Kuhn, and Fleming made payable to Forge for $403,500. You see that?
Yes, sir.
When was this approved to be paid to Forge?
Believe the disbursement settlement statement I signed was January 7th.
And it said it was going to go to Forge?
I think so.
Okay. So from the $505,000, $403,500 was supposed to go to Forge?
Yes, sir.
Okay. What was the contingency fee that Corey Fleming was operating under?
I don't know.
A third?
I have no idea.
40%? It was a third. He didn't take as much a fee as he should have from that, is there? He didn't take, if it was a third, $166,000 or some odd dollars should have been taken off the top, right?
Yes, sir.
Okay, but $403,500, which should have left about $101,500. That's what should have been left. Did you ever try to get an accounting of all that?
I did not.
Was it your responsibility to have an accounting for the estate?
Yes, sir.
Okay. So this check was written, right? Is it endorsed?
I don't know. Looks like it says deposit only to me.
Is that an endorsement?
I wouldn't think so.
You're a banker.
Yeah, I wouldn't.
If you're the payor bank and Leiden National Bank presents a check from one of its customers, Cindy, and says, we want you as the payor bank to pay the funds, and you saw that, you would send it back to Leiden National Bank and say, can I get an endorsement, right?
I guess, yeah. I mean, sometimes it is. I would say you could see them going through like that, but usually the account number is attached to it or whatnot. But
Have you ever, in your experience, seen a check be sent back to a collecting bank and say, look, we need an endorsement on it, we can't honor the check?
No, I haven't, but I don't deal with that. I don't turn
Okay.
deal.
So you weren't
checks.
ever, before
I'm
you
not.
became the big honcho, you never
I'm
were
not
a
a big
lower honcho? You were, before you became executive VP, you weren't a teller?
I was a teller way back at a different bank. Yes,
Okay.
I've never been a teller at Palmetto State Bank.
All right. But it's important to have endorsements,
It's
right?
very important, yes, sir. And to go back to it, like, when I endorsed the check as Chad Westendorf as PR for Gloria Satterfield's estate, I did
wrote
it
out
exactly
how
the
it was
check.
written on the
Yes.
payee.
Yeah.
The payee determines who should endorse. Okay. So the next exhibit is 15. This is the disbursement sheet that
Yes,
you
sir.
signed. And you are correct. You signed it like you
Yes.
said.
Yes, sir.
Chad Westendorf is PR of the estate,
Yes, sir.
right?
Yes, sir.
And you signed it on January 7th
Yes, sir. In my office.
in your office. Tell me how you signed this settlement statement like that with those kind of disbursements. What do they mean?
I don't know.
Well, the settlement was for $505,000. And you signed a settlement statement saying the settlement was for $475,000. You saw a check come in for $505,000. You endorsed it. You told the judge on December 19th that the settlement was $505,000. Who prepared this disbursement sheet?
I don't know.
Did Alex prepare it?
He brought it.
He brought it to you?
Yes.
Where, at the bank?
At the bank, yeah.
Okay, so Alex brought you this document. Did you not read it and say, hey, Mr. Alec, the settlement is $505,000?
No, I did not.
You didn't? Okay. Did you see that it had only $50,000 of attorney's fees?
Yeah,
Did you ask what's that in reference to? What percentage? How did you arrive at
I
that?
did not.
And it said you get $10,000.
Yes, sir.
How was that determined?
I don't know.
And you did get $10,000. I
Yes,
saw.
sir.
there
Yes,
were-
sir.
You did.
Yeah.
And then it said there was prosecution expenses of $11,500. And it says, I understand and fully approve the above disbursements. I acknowledge the receipt of the above amount and a copy of this statement. So you're approving $11,500 of expenses. What did you base that on?
I don't know. I didn't have any proof.
Did you sign and give this to Alec, or did you provide this to Corey?
I gave it back to Ellen.
And you signed it?
Yes, sir.
Okay. And so it says that from that, $403,500 is going to Forge.
Yes, sir.
And we saw that check,
Yes,
right?
sir.
Can you tell me where the other $30,000 went to?
No, sir.
That's $30,000 that belongs to my client, right?
Yes, sir.
And Alec and Corey are representing to the court in these papers that it's a $505,000 settlement, yet you're signing a disbursement sheet that it's only a $475,000 settlement.
Yes, sir.
Do you owe an apology today to my clients?
I'm sorry this happened to him. Yes, it is.
I appreciate that, and I know they're going to appreciate
And I'm sorry they lost their mother more than anything. I mean,
And I know they're going to appreciate that too, and I thank you for that. The date of the injury is February 28th, 2018. What date's that? She fell on February 2nd. She died on February 26th. What is February 28th? Don't know.
don't know.
Our next exhibit is 16. And this is you writing, this is one of the only emails that I've seen you write, and you sent it on your email at Palmetto State Bank, and you wrote it to Corey, and you said, "Good morning, Corey, hope all is well. Could you please send me a copy of the document that we signed with the judge the other day? Just want to keep a copy." You see that?
Yes, sir.
What made you want to write that on January 14th?
It was after the 7th, and we signed that, and I never received any of the documents from the 19th meeting. And I was wanting to keep them.
Okay, did he ever send you any?
Yeah, I got those.
You did?
Yes, sir.
Okay, I'm gonna, hold on here for a second. What did you get?
It was a copy of the agreement dispersed, the one you had earlier.
Yeah, I'm gonna show you. Well, I gave you that disbursement, but hold on.
No, it was,
I'm gonna show you something right here.
okay.
So, exhibit number 17.
No, he didn't send me that.
This is the order approving the wrongful death and survival settlement from that hearing. And I'm really concerned because I've never seen a signed copy All I've ever seen is an unsigned copy. Did you ever see a signed copy by Judge Mullen
No, sir.
from that settlement?
No, sir.
So the document you were asking was probably the
one I
the
signed.
disbursement sheet
Well,
from
that,
January, or the petition.
the petition, that's it. yeah.
So you signed the petition and you
Yes,
wanted
sir.
a copy of the
Yeah,
petition.
yeah. I
Well,
did.
if we go back to the petition, and I'll take you back there real quick. It's exhibit number 13. Hold on. Yep.
Yeah, that's what he said.
It says there's a $505,000 settlement, doesn't it?
Yes, sir.
Okay. The order that was drafted says only it was $475,000. So do you know how, when the change came from 505 to 475?
No, sir.
Okay. And to your knowledge, did you ever see a signed Judge Mullen order from the first one?
This was the
Yeah.
first one. No, sir.
No. Okay. So the structure is discussed, but you don't see the check going to Forge, right?
No, sir.
And you never communicated with Forge, right?
No, sir.
And you never saw an insurance policy, right? An annuity policy, right? Okay. And you would agree to me that Alex was the one that talked to you about a structure, right? You heard Alex talk?
It was in there in the meeting with Corey and Alex.
And they talked about a structure?
Yeah. Well, they talked about Forge.
Forge.
The money was going to Forge is what I heard.
Okay. And you didn't ask who's getting what
I did not.
the terms of a annuity would be, how long it would go, how it's funded, how it would be paid. And you would agree with me that that's a business decision that you should have weighed in on for your heirs, right?
I understand that.
Object to the form.
Because the heirs are entitled to their money that the court orders when they're over the age of 18, right? Over
I
18,
understand
you
that.
get your money.
Okay.
As an intestate heir, Gloria died without a will. You understand that?
I did not.
Okay. Do you know the difference between testate and intestate?
I do not.
Do you know now?
No, sir.
Okay. So she died without a will makes it intestate. So the law would say that if she had a husband and 2 children, husband gets 50%, kids get 50%. But she died without a husband. So all the money went to the kids. You knew that they were the heirs of her estate, right?
Yes, sir.
You just didn't know whether they were heirs based on a will or based on intestacy, right?
Correct.
Intestate, okay. So if you are permitting money to go into annuity, you would have had discussions with the children, the boys who are 30 years old and older. You don't want the cash now, you're going to put it in a structured annuity. Did you have those discussions?
I did not.
Did Corey tell you you should have those
He
discussions?
did not.
Okay. So what's the next thing that happened after you got your $10,000? That's the only thing you really knew about. You didn't even know the $403,500 was sent to Ford.
I did not.
You weren't copied on a cover letter that Corey sent to Forge, depositing, sending the check.
No, sir.
If I told you that Corey just put that check in an envelope and sent it to a P.O. box in Hampton, would that surprise you?
Very much.
Addressed to Forge. And there wasn't a cover letter. So if there really is a Forge, which there is, Forge Consulting, and so the Forge check goes to Forge, what's Forge supposed to do with a Forge check? It doesn't say on the bottom, the Satterfield kids, or I'll show you the check again.
Yeah, that's right.
It
Yeah,
doesn't-
how would they know? I agree.
I mean, if I send $10 million to Zurich Insurance Company today, how are they going to apply it? Where does it go? And in this case, there's 2 boys. On the bottom, it should have 2 account numbers, to say, look, split the proceeds, something. And you heard Corey Fleming, through his lawyers, say, I was duped. You've heard that, right? Have you heard that Corey Fleming, through his attorneys, Corey hasn't spoken,
Okay.
but Corey's attorneys have said he was a victim. He was victimized by Alec. Alec hoodooed him, that he was unwary or ignorant that Alex wasn't actually doing anything with forge, there wasn't a forge. I mean, the whole concept, think about this, that you're letting the defendant, Alec Murdaugh, have these discussions with supposedly forge and setting up the structure when he's the defendant. Doesn't that strike you as a conflict of interest or crazy?
Should.
Should. Okay, it didn't. Did they ever say where Forge was located in the hearing in front of Judge Mullen? Did they say it's located in Georgia or
No.
Hampton or
I did not
Columbia, South Carolina?
hear that. No.
Okay. All right. So you get the 10,000. You don't know about how Corey dispersed it. You don't know about that. There's $30,000 that's unaccounted for. You only get a petition that you signed. So at this point, you have your signed petition that was filed with the court on the 19th. Did you get a copy of the disbursement sheet that you signed?
I made a copy, yes.
Okay, so those are the two documents that you have, along with when you became PR on the 18th.
Yes.
Okay, so that's kind of your file at that point.
At that point, yeah.
Okay.
I did, yes.
So what happened like during the rest of January and February? Were you getting ready for the meeting?
Next thing I received was a letter stating that they requested me at a mediation.
Mediation.
And I believe the mediation date would have been March 21st, something like that.
Yeah,
I'm not going to
yeah.
swear to that.
Yeah,
'cause
it's
I
the end
don't
of
know.
March.
Okay.
And you
there
were out of
should-
town.
No, there should have been some emails to Corey that stated that the bank was running low on people and I wasn't going to be able to come in person. I said I could show up on Saturday, and he said, no, let's do it over the phone.
Okay, I've never seen those emails, but
Okay.
I trust you.
Well,
I trust you that they're in existence. I didn't see them in your file, and I didn't see them in Corey's file.
okay. It was just, I could not make it.
Right.
We're having trouble at the bank. Not trouble, but
But
we're
they're
having-
short on staff.
Short on staff, and I need to remain there.
Okay, so did you have preparation for the mediation?
No, sir.
Did you ever think, I need to start talking to the boys to figure out what's going to happen to all this money? Are they satisfied? What state they're in? You know, if somebody says I'm going to buy an annuity for these boys, don't you have an obligation to find out whether the boys may need the money today? What if, Brian had cancer and he needed the money? What if, Tony needed dental work, which he does? Did you have any of those discussions?
No, sir.
Okay. So the next exhibit is 18. So now we know we're going into a mediation. The mediation actually settled for $3.8 million. And you were on the phone, or were you available by phone?
I was available. I was on several times during that day. Mm-hmm. And I was told the date of mediation that no settlement was reached.
Okay.
And then I got a call later, a couple days later, to let me know that it was
3.8
offered, and that if I was okay with him accepting that.
I'm sure you gulped when you saw 3.8.
Yes, and I thought it was a very,
I will tell you this, and obviously Ronnie Scott and I represent Gloria, and we've learned a lot about Gloria, a wonderful person. But where we practice, that's an extraordinary settlement of $4.3 million for a 57-year-old lady that basically earns $11. Not to minimize her life, what she's worth, it's priceless, but from lawyers, and he does defense work, economically, you say, okay, there was $600,000 in medical bills, she had this much of lost income, maybe you could get $1.5 to $2 million settlement, but $4.3 million is just extraordinary. And I'm sure you felt the same way. And you're not even a lawyer.
no.
And you're not even a guy that's aware of this. I'm just telling you, we were flabbergasted and impressed with Corey Fleming, to be honest with you. Now, we do have a little more information than we initially did, which was that Alec was pressing the hammer on his own insurance companies and saying, look, if you don't settle this, there's going to be an excess verdict. It could be more than the $5 million of coverage or whatever the excess is. And if that's the case, it comes against me personally. I'm going to sue you guys for bad faith. You ever hear those kind of terms? And Alex kind of told the carriers, look, this is going to be tried in Hampton County, my jurors. I've seen this in the insurance file, just to let you know. And that I'm going to stand up in front of this jury and say, it's my responsibility that this woman died. It's my fault. And so the analysis of the insurance company was, they're very scared of Alex in front of a Hampton County jury, and that's why they made the decision to settle for $3.8 million. So you get called on the phone, and you're like, yeah, it's a good number, take it. It's not like you didn't come back and say, well, Corey, do you think you can get $5 million? You didn't say that, did you? No, I mean.
I'm just curious why everybody involved's on here and they don't include me. If they know I'm the personal representative, I'm supposed to be in this stuff.
So when you're at this mediation, you're aware, because you're in Hampton County, that Mallory Beach died.
Sure.
And the whole landscape started to change because reporters, both statewide and nationally, started to descend on, this beautiful county. Yesterday, I actually was in Hampton. I'd never been there before. I ate at coconuts. It was quiet, but I'm sure at different times it wasn't quiet in that town, that there were a lot of reporters and cameras there and everything. Did you get an impression at the mediation that the Mallory Beach death had an impact on this in any way, shape, or form?
Not at that time. It wasn't brought up.
Okay, well, if you look at 18, this third paragraph says, John Grantland says, my office will work on the court approval documents ASAP, and the agreements we prepare will all have doesn't make sense, the In re Gloria Satterfield caption. You see that?
Yes, sir.
It says, Corey, if you want to structure some of the proceeds of the settlement, please let me know, and I'll be happy to put the PR in touch with the structured settlement broker. You see that?
Yeah.
So John Grantland thinks that you are involved in a structure. He thinks because you, as the PR, are the people for the estate, you have to speak to the structure people. You see that?
I see that. Yeah.
Okay. Do you know how a structure works?
No, sir.
Okay. Do you know how a plaintiff's attorney interfaces with the insurance companies who do the structure?
No, sir.
Okay. Do you know if the attorney, the plaintiff's attorney, receives the check and it's in his possession, whether you can do a structure?
I do not.
Do you know that Corey Fleming, and I'm going to show you an exhibit, about a year and a half before this, actually received from Forge Consultants an email that said, Corey, this is how a structure works. If the money touches your hands, the settlement proceeds, you can't structure. The only way a structure works is the payor insurance company sends the check to the structured insurance company. They buy the structure, the annuity, and then whatever the net proceeds are supposed to go to the attorney for his fees, or net proceeds to the beneficiaries that they're supposed to get from the settlement, the structure company settles it. Did you know that's how it works?
No, sir.
So that's how John Grantland knows how it works, because he's putting you in touch with the structured broker, not Corey. He's not saying, Corey, I'm going to put you in touch with the structured insurance company. He's saying, I'm going to put Chad Westendorf in touch. But you had no idea about that. Now, if you read the third paragraph, it says, we're going to change the caption. Do you remember having those discussions at the mediation?
No, sir.
You weren't there, you weren't on the phone, or nobody called you. Now, I showed you the caption before.
Yes, sir.
It was the estate of Gloria Satterfield versus Alex Murdaugh. And you're the PR, it said the PR, excuse me, of the estate. You're the plaintiff. Did you consent for your caption, you being the plaintiff, to be changed to In re Gloria Satterfield?
No, sir. And
Do
I
you-
don't know what that means.
Do you understand? In re is just a term that estate lawyers like Tommy use. It means, in the name of. But it doesn't even say decedent now. Now it gets a little bit squirrely because it doesn't say In re Gloria Satterfield decedent. It just says In re Gloria Satterfield. And that can mean a person that's incapacitated because they're in the hospital. You didn't consent for that caption to be changed, did you?
No, sir.
Nobody asked you.
Nobody asked me.
And if you were asked, would you take your name off as a plaintiff on that caption for the estate?
No, sir.
Did you ever hear that the reason they're changing the caption and whose name got taken off that? Your name? Right?
Yes.
And the guy on the other side of the V was who? Alec.
Yeah.
His name was taken off.
I wasn't.
Yeah, well, now it's Imre Glaze and Gloria Satterfield. So, did you ever find out that the reason they wanted to take the caption off was because Alec didn't want Mark Tinsley, who was representing Mallory Beach, to find out he was settling a case and paying a lot of money? Ever hear that discussion?
Repeat your question, please.
Ever hear that discussion? That the reason Alec's name was being taken off that caption was he didn't want Mark Tinsley, who was suing him, suing his son for the Mallory Beach boating accident. He didn't want anybody to find out of public record that this kind of money was being paid from his homeowner's insurance carrier.
The only time I heard that
Was in Chambers.
In Chambers, yes.
At the second settlement
Yes,
conference.
yes.
And
that's where
Alec wasn't even there.
He wasn't there.
Okay. And that was said to Judge Mullen.
From Corey, yes, sir.
And Judge Mullen says, I understand.
I understand.
And Judge Mullen, did you know, had recused herself a month before from the BUI lawsuit? BUI meaning boating under the influence. I'm going to show you an order that a month before you had your hearing, she recused herself from hearing anything having to do with Alex Murdaugh and Mallory Beach's death.
I did not.
Did she discuss that to you? Did she say to you, Mr. Westendorf, you're the PR for this estate, and I need to disclose to you that I have recused myself 1 month before from having to do anything with Alex Murdaugh and the Mallory Beach death?
No, sir.
Okay. So you didn't see this email where they're going to change the caption?
No, sir.
Okay. So the next document is 19. This is the settlement agreement.
You got another one? Here.
Oh, sorry. I'm sorry, Tom.
Thank you.
Do you remember signing this settlement agreement?
No, sir.
Okay. Do you remember seeing the settlement agreement? That it said,
I don't remember seeing this.
okay. Do you
No,
remember?
I don't remember seeing it. I'm sorry. She told me to speak
Okay.
up.
Do you remember the statement at the bottom, right before the bottom, it says on the front page, the settlement petition in order shall not have an adversarial caption. Do you remember seeing that language?
No, sir. And I
Okay.
don't know what that means. So.
Okay. Well, obviously,
I know now.
it's
Yeah.
a V.
Yeah.
You know,
Versus.
Chad versus Eric.
Yeah.
Now it's going to say In re Gloria Satterfield. Okay. Let's take a 5-minute break, okay?
Okay.
This is the end of Media One. The time is 11:32 a.m. We are off the record. The time is 11:37 a.m. This is the beginning of Media Two. We are back on the record.
So I'm showing you exhibit number 20. This is where Judge Mullen on April, I think it was 4th. Yeah, April 4th, or April 10th, excuse me. She recused herself, Judge Mullen has recused herself from hearing all matters related to this case and forwarded to justice for reassignment. And so this is the Mallory Beach case versus Gregory Parker, and ETAL means that there's other defendants. And you were unaware of that when you went into that hearing? So when you went into the hearing on,
Excuse me.
April 13th, it was just you, Corey,
May 13th.
May 13th, you and Corey,
Yes, sir. And Judge Mullen.
and Judge Mullen. And again, that was not on court record, and it was not in a courtroom,
No, sir. It was in a room off there.
room off there, okay. And did it strike you funny when Judge Mullen said we're going to change the caption and take Alex's name off?
I didn't know that happened until you just told me.
Well, you said there was a discussion in front of.
Not
court.
about taking the caption off. The only discussion we had was he claimed, or he told Judge Mullen that that Alex's attorneys would appreciate or would not want her to file the order at this time. I didn't know anything about a caption.
Okay.
They asked her.
Did
she
they
asked
say
not
the
to
reason
file because of
the
the recent boating accident?
The recent voting,
Yes.
and he was being sued.
Yeah. Well, I didn't know about being sued, but she just said the publicity over the recent boating accident.
And that's why she said, I'm going to sign the order, but don't file it.
Yes, it wasn't filed.
Okay. She said, don't file it.
Corey asked if it couldn't, I'm going to file this later. I don't remember the judge saying don't file it, but Corey said we want to file this later.
Well, we're not going to.
Oh,
It was
I don't
never
know how
filed.
it all works. Okay. Yeah.
It was never filed.
Okay. It was
And so
under,
he told her, we're not going to file it because of the publicity over the boating accident. And she said, okay.
yes.
Okay, and then signed the order.
She signed something. I cannot say that was the exact thing she signed, but I was in there when she agreed to it
Okay.
verbally.
And so the next document is 21, which is a release that you actually did sign.
Yes, sir.
And you signed as Chad Westendorf, personal representative of Gloria Satterfield on the 11th of April.
Yes, sir.
And this is where you're agreeing to release these insurance companies for the payment of $4.3 million.
Yes, sir.
Okay. And so then on April 22nd, exhibit number 22, yep. The check is actually sent in the amount of $3.8 million, and it's made payable to you and to Moss, Kuhn, and Fleming as the attorneys, correct?
Yes, sir.
And you signed the check.
Yes, sir.
You endorsed it.
Yes, sir.
You didn't put for deposit only, you put Chad Westendorf as personal representative of the estate of Gloria Satterfield.
Yes, sir.
You see an endorsement by Moss, Kuhn, and Fleming on there?
I do not.
Okay, so that check wasn't even correct.
Well, this was from me. I made a
Right.
copy of this, so I don't know if I may.
You don't know if, when he took the check, that he may have put,
His investigator brought this check to the bank for me to sign. That's how I had copies of these, and I sent them to you.
now, this is to Corey Fleming,
Yes, sir.
and you see the second sentence. It says, please hold these settlement funds in trust until the petition and the order approving the settlement have been signed and filed at the probate court settlement hearing.
Yes, sir.
Now, you just told me that you were aware that there were discussions between Corey and Judge Mullen where they agreed not to file this. And you got a copy of this letter. Did it strike you as strange when you're in the settlement conference and they're discussing not filing it of record when the man who sent the money said, look, this is to be held in trust until it's actually signed and filed, the order? Never thought of that?
I thought he would hold it until it was filed. I mean, my interpretation of, never mind,
Right. All you heard was that he asked Judge Mullen
to wait.
to
Yes.
wait to sign it, and we're not going to file it. And she said, okay.
Yes, sir.
Okay. So then the next document that I'm going to show you is 23, which is the petition. And again, you're not a lawyer, but you will see that the caption now is just In re Gloria Satterfield. It's not Chad Westendorf as personal representative for the estate of Gloria Satterfield versus Alex Murdaugh. It's not even In re Gloria Satterfield estate. It's not even decedent. It doesn't even tell the world she's dead. Right?
That's what you say. I don't know what that means. I've told.
Gloria Satterfield.
That's all. That's all that means.
I mean, I can't look at the name Gloria Satterfield and know she's dead.
Oh, I understand that, but I didn't know
Because
what
it
in re
usually
means.
says decedent or estate.
I got you.
And there's no docket number. Right? So when you walked into the chambers with this petition, which you signed
Yes, sir.
as Chad Westendorf, you signed the verification and you signed his PR.
Yes, sir.
When you walked into the chambers, did Judge Mullen not say to Corey Fleming, where's the petition that I'm supposed to rule on that's filed of court record? How is this caption the new caption when the caption that's filed of record is Chad Westendorf versus Richard Alex Murdaugh? Did she not say, Mr. Fleming, what are you doing with this caption? Where is this? There's no order. You understand that if a caption, you probably understand now.
Yeah.
You have a court caption. It's in the court record. So a clerk of court will type up a caption and it'll come up. If you're going to change a caption, a judge has got to approve that so that the clerk of court can change the caption. There's got to be a way to search records and file stuff that it gets filed right.
Yes, sir.
Did not Judge Mullen say, Mr. Fleming, what are you doing bringing this caption in here? I don't understand. It's not even filed, this petition. She didn't say that.
I don't remember anything, even discussing that. Like I said, that's the first I've heard of that today.
Okay. And so the next document is 24. This is the actual order that she initialed and signed. Right?
She signed something, like I said. I
Right.
wasn't standing over her shoulder, but I mean, we were discussing it and everybody had paperwork, so yes.
Okay. And so this was filed in December. It's not, she didn't file it. The filing on there is a December 2021 in another
Yes.
court filing.
Yes,
But
sir.
she didn't, this was never filed of record. And you signed the disbursement sheet.
Yes, sir.
And this is now a combined disbursement sheet. There's $505,000 that was the Lloyd's first settlement,
Yes,
right?
sir.
There's the $3.8 million, which was the Nautilus settlement.
Yes, sir.
Attorney's fees from the first one are $168,333.33 from Lloyd's and $1.2 million from the Nautilus settlement, right?
Yes, sir.
But we already went through the disbursement sheet that you signed on January 7th,
Yeah.
and that wasn't a settlement of 505, it was a settlement of 475. You didn't catch the
I
difference?
did not catch that.
And $403,500 was already sent to Forge. We saw that check.
Yes, sir.
Which leaves $101,500. Where was the $168,000 of attorney's fees going to come from? Then you signed and approved $105,000 of prosecution expenses. And you're saying, I fully understand and approve the above disbursements. What did you do to avail yourself that there was $105,000 of expenses? And if you approved 11.5, and I know it's embarrassing for you and it's painful, but if you approved the 11.5 on January 7th, right,
Yes.
of expenses,
Yes, sir.
how was there an additional $105,000 between January of 2019 and the May 13th, 2019 hearing?
No idea.
It's not credible.
It's not.
There wasn't ongoing litigation. There wasn't depositions. The estate wasn't paying Corey by the hour. He was taking a contingency fee up top. You see his contingency fee. And where does that? How does that make sense? Other than it's just Corey stealing.
It doesn't make sense.
So the net, it says that you're going to oversee, that's going to go to my clients, is $2,765,000. You're going to oversee that. You're going to make sure that this gets dispersed this way. And you understand when Judge Mullen signs this order and she sees this disbursement sheet, she expects that it's going to be dispersed exactly how it was presented to her by you on this sheet. Okay?
Okay.
All right. So then, we have another disbursement sheet. And this is Exhibit 25. And now it shows the same settlements, 50538 up top. You see that?
Yes, sir.
But now it's saying from the Lloyd's portion, they're only going to take $50,000 of settlement monies. You see that?
Yes, sir.
Previous document, they were going to take
160.
166,
Something.
168. And now they're saying they're only going to take $600,000 from the Nautilus, where the previous document they told the court they were going to take 1266. You see that?
Yes, sir.
And now the prosecution expenses are, there's a mediation for $1,500 that pays the mediator. And then you got paid another $20,000. You see that?
Yes, sir.
For a total of 30.
Yes, sir.
How was that determined?
I have no idea.
And then the only other expenses are a 5559, and then there's two $8,000 and $8,500 expense checks, and you never figured out what they are for.
Nope.
And then prosecution remaining in trust, $191,000. You see that?
Yes, sir.
And they have these forge checks here. You see those?
Yes, sir.
But this was never signed by you.
No, sir. Never saw it.
You never approved it.
Nope.
The only one you approved was the one you signed. But somehow this document was created as well. Okay? So the next document is exhibit number 26, and I had promised you I was going to share this with you. This is the document that Michael Gunn, and I'll represent to you, he's the guy from Forge Consulting LLC. He says to you, because it's a minor, I'm assuming you'll need circuit court approval, which can avoid probate. I would recommend we do a minors pool trust, During the years, minority can pay, and then we have the balance, it's invested or whatever. But he said, because the receipt of the funds in your trust account has already occurred, a traditional structured settlement is not possible unless you want to send back the funds to the defendant and have them reissue the checks and change the release. So Corey is already told, and this is in December 2017, a year and a half before all this takes place, you cannot receive these monies into your account. If you do, there's no structure. The structure can only take place if the checks go from the payer insurance company to the annuity insurance company. So he's already on notice. So when he's writing checks to Forge, after he gets your endorsement on the check and deposits in his trust account, he knows that it can't be a structure. And he's telling the world in this, through his lawyers here, that he was duped by Alex. He didn't know what was going on. He thought that Alex was buying a structure, whatever. But the threshold thing is he already has been told by Forge the company who's supposedly going to write the thing. You cannot take possession of those funds and put it in there. This is not your fault. I'm just telling you.
I appreciate it.
On the people that you were dealing with. So the next exhibit that I'm going to show you is 27. Almost done.
Thank you.
So on 27, the check is made payable to the same day as the hearing that you had, May 13th, 2019. Corey writes a check to Forge for $2.9 million. And your signed disbursement that he was supposed to write it to was my client's, and your client was supposed to get $2.7 million. Did Corey ever tell you we need to go back to Judge Mullen to get her to approve this disbursement this way?
No, sir.
And you didn't even know that he was sending that check?
didn't.
He didn't provide you with a copy of that check?
No, sir.
And again, it's sent to Forge without any remitter at the bottom telling it this is the Satterfield structure, this is for Brian or Tony, half goes to Tony or 60% goes to Brian. I mean, what is Forge, if there's a real Forge, what are they supposed to do with this check? Now, this was endorsed properly. It says Alex Murdaugh, DBA Forge. Now, we know that Forge was a fake because Alex was not in the structured annuity business, but he opened this account. But this is a correct endorsement, assuming that the check was legitimate. So that if it went back to BB&T, the payer bank, they would have to honor it because there's a disbursement as long as there was an endorsement, as long as there were funds in the account. Okay. So the next check is 30. Nope, is 28. Excuse me. And this is, yeah, this is for $600,000, and that's not what was supposed to be on the attorney's fee disbursement that you had. It was supposed to be for $1.2 million that they were supposed to get. And again, you didn't see this check, right?
No, sir.
And it doesn't say in the reference, hey, this is for the Satterfield money, okay? So the next document is exhibit number 29. And this is where they're withdrawing their statement for $95, Michael Sarton. You see this? This is a creditor's claim. Now, he didn't withdraw the $665,000 creditor claim. He withdrew a $95 one. Did you get a copy of this?
I did not.
And it was sent to the Hampton County Court, and again, it's in the probate court, and you never got a copy of it.
No, sir.
Okay. So the next document I'm going to show you is exhibit number 30. And now it starts to get really crazy. Sorry. This is a stipulation of dismissal. And it's signed by Corey and Alex. Did you know that Corey signed this document a year and a half later on October 5th of 2020 on your behalf?
No, I did not.
Did he get your permission to sign this document?
No, sir.
And Alex signed this document on his behalf without any lawyers. Do you see that?
I see that, yeah.
And this is the dismissal of the only caption that exists in the courthouse. The one that started when you started on December 19, 2018. It was Chad versus Alex Murdaugh. And there's the court term and number up top.
But that wasn't on the other one.
Where is the dismissal of that? where's the in re Gloria Satterfield? It doesn't exist, does it? And so the very next day, I'm going to show you exhibit number 31. Corey writes forge again, $118,000. No reference, doesn't say it's pursuant to the Satterfield. It doesn't allocate between Brian and Tony. And that account was supposed to be zeroed out. If you look at your disbursement sheet that you signed on May 13th, everything was supposed to be written out and there would be $0. The 2.7 goes to the client, you get your fees, the attorney's fees. There wasn't supposed to be any money left over. Yet, almost a year and a half later, there's another $118,000 that Corey is writing to forge without any court order. There's never an approval either by you or by Judge Mullen or any judge saying another $118,000 can be written to forge. And he didn't call you on the phone and ask your permission. And did you assume in October of 2020 that all the money had been dispersed and there was nothing left?
I did.
Right. And you don't get a copy of this. You're not told of this.
No, sir.
And Corey represents you, and you'll see this doesn't have an endorsement on it, does it?
It's the deposit only.
It says only deposit only. And so the dismissal's done the day before, and it looks like somebody's trying to zero out an escrow account because $118,000 goes to forge. Did you ever see a forge insurance policy?
No, sir.
A forge annuity?
No, sir.
And we've already said that you never discussed this with the boys or talked to the boys. And then you learned something at the mediation that we had in September, that even after Corey wrote that $118,000, he still had another $113,800 in his trust account. When you heard that day, were you shocked?
Yeah. I thought it was all over. I mean,
And what was the $113,000 still doing in his escrow account? There was no more defendants. There was no more people to prosecute. They exhausted the primary, they settled with the excess. And it's just a real shame, I think, when you see how all this happened. So now I'm going to show you exhibit number 32. Here's you getting your first 10, right?
Yes, sir.
You endorsed it, was written on January 7th, right?
yes, sir.
Okay. And then I'm going to show you exhibit number 33. Yep, 33. And you wrote these for me, right?
Yes, sir.
And you acknowledged that you had been paid, that you're going to return the $30,000,
Yes, sir.
and that you actually went to Russ, and contrary to what the bank said, that they initially said they were unaware of it, you actually gave a statement on October 1st saying that you had gone to Russ and told him that you would be a PR, or asked him, and he said you could be, right?
Yes, sir.
Okay. So now, my next exhibit that I'm going to show you is 34. This is Corey writing himself a check for $8,000 on January 17th on this escrow account. And for $8,000, do you know what he would have spent $8,000?
I do not.
Okay. The next exhibit is 35. And you filed this on September 21st to no longer be the administrator of the estate. Is that correct?
Yes, sir.
Okay. And then on 36, you filed your final accounting that we discussed earlier.
Yes, sir.
And it's the same 26,000 that existed, right?
Yes, sir.
And we already discussed that you never got a hold of the 50,000 that should have gone to the probate court, right?
That is correct.
Okay. And then exhibit number 39, oh, 37, sorry. Is you agreeing pursuant to our agreement, you sent back the monies, the
Yes.
$30,000.
Yes, sir.
Is that correct?
Yes, sir.
And that disgorged you of all the fees that you made, right?
Correct.
And then 38, is the $113,800 that still remained in the escrow account, right?
Yes, sir.
And we'd have no explanation for that, right?
I have no clue.
And then 39, this tells the story. So this is the escrow analysis account of the monies. So it shows $505,000 coming in on December 19th, the day after you were appointed. Then on January 7th, $403,500 was paid to Forge, right?
Yes, sir.
Then $10,000 was paid to you, which we already showed. Then $8,000 was paid to Corey Fleming, which we showed, and we have no idea what that $8,000 represents. Moss Fleming got $50,000, but under the order from Judge Mullins, they were supposed to get $166,000. Then Corey Fleming takes another $8,500. You see that?
I see that.
On April 3rd. Did you know what that was for?
I do not.
The only legitimate cost was the mediator that was $1,512, which is John Austin. Then the $3.8 million is deposited. $2,961 goes to Forge, what we already saw. You got your $20,000, which we've already seen. And $600 went to Moss Coon when it was supposed to be $1,266 million.
Yes.
And then another $9,700 went to Corey Fleming. You know what that was for?
No, sir.
So we have almost $27,000 worth of checks written to Corey from this account for personal expenses, which never existed, which is pure theft. And then there was the $118,000, I showed you that check that was written on October 6th, which left $113,800, which was wired to my account.
Okay.
So that is the saga of this. And you are still employed by the bank, is that correct?
That is correct.
Are you still the president of the Banking Association?
That is correct.
Okay. So you're not allowed to tell me, but have you testified before a grand jury?
I'm not allowed to tell you what.
The substance of it, but have you testified?
Yes.
Okay. And outside of testifying before a grand jury, have you also been interviewed by SLED?
Yes.
And gave a statement to SLED?
Yes.
And you gave a 302 to, have you been interviewed by the FBI? Or
They
just
were,
SLED?
they were there with SLED.
Okay. So that is not privileged, as is the grand jury testimony. So I was told that in your statement, you made a similar statement about Judge Mullen, that Judge Mullen knew that the order was not going to be filed.
Yes, sir.
Is there anything else that you have said, that you said in there about the two hearings of Judge Mullen that's different than what you said today?
I don't recall anything different. I think.
Do you think that based on your personal observation, do you think that Corey Fleming hoodooed Judge Mullen?
I don't know.
Judge Mullen knew that that order was not going to be filed.
Yeah.
And the reason was because of the Mallory Beach case, because of the public scrutiny that was attached to it at that time, and Mark Tinsley suing Alec and Paul. Paul had not died yet, and the convenience store parkers and some other people. Is that correct?
I believe so.
Okay. I have had some other people consult me, obviously, other than the Satterfields, as this all has unfolded. And I'm noticing in a lot of the files, let's say for Jenks, Jordan Jenks, and I'm noticing in Sandra Manning, that after they signed up with the Murdaugh farm, they would come to your bank and borrow money. Are you aware of that? That loans would be done. So for Sandra Manning, I have her borrowing a total of $1,500.
Okay.
$500 3 separate times. And the interest rate on her loans was 29%.
Okay.
Did you ever do those loans
I used to. Several years back I did.
for the Murdaugh firm?
And there was other firms. that
Other
did.
firms?
Yeah.
Okay.
It,
How would interest rates be determined? Would they be negotiated with the customer? Would Alex negotiate them, or the attorney for the law firm, or you just would set the interest rate?
I was hired 23 years ago, and when I came there, they explained to me, we called them lawyer loans.
Right.
And they were done with people having cases, and they would be paid out of the case.
Right.
Okay, 18% across the board is what they were. It must be an APR that you were looking at for 29, but most of them were a set rate of 18%, and they were done for 1 year at a time.
Okay. And then, like Jordan Jenks, I had his are 22%.
That must have just been the APR, because I mean, all of them, from my recollection, every one I did was 18%, was a fixed rate on those. And I don't know how that was set, where the policy was.
Is there a default interest rate other than the regular interest rate if they go in default? Do you know?
I don't know.
A different rate?
Yeah, no, I don't know.
To your knowledge, what happens if they weren't repaid? Did you guys ever go after the client, or you would just write off the loan?
I don't know.
In your experience, the loans that you wrote, were they all paid?
They were all paid. I don't know.
They do a pretty good job.
I mean,
Murdaugh does a pretty good job of collecting money.
Well, I mean, and they, yeah,
Yeah, because you're paid from the settlement proceeds.
that's correct.
And then it's calculated based on when the loan started to when the repayment happens.
Correct.
You know, this is new to us in the Midlands about lawyers taking clients to a bank and getting them loaning money. It's done for, you know, I guess the Gooding and Gooding firm and all those other firms down there, they do that. Why do the customers need the money? Is it just normal living expenses?
I have no idea.
You know, I see loans like 1,000, 1,500, 500. I mean, was that kind of the area? You weren't loaning like 100 grand to somebody on a case, were you?
I never did. All that I ever did.
Were
and
modest.
I saw, and usually around Christmas they were bigger. I mean, not bigger, but more
Right.
coming in.
They could come back and re-up and get more loans.
That's
Okay. That's all I have. Thank you very much.
Thank you.
Great.
Appreciate it.
Now, will
This-
I be able, oh, I'm sorry.
This concludes the deposition of Chad Westendorf, media number 2. The time is 12:14 PM. We are off the record.